Hey guys, welcome back to the channel. Today, we're diving into 3 incredible sovereign citizen courtroom showdowns, and every one of them is a follow-up to cases we've covered before. One of these cases even serves as the dramatic conclusion to a sovereign citizen saga that has stretched across multiple states and countless courtroom battles. From failed legal arguments to judges running out of patience, these hearings deliver plenty of twists and unforgettable moments. Let's get right into it.
All right, and court will call People versus Robert Geese, 26T884. And Mr. Geese appears in the courtroom. Mr. Geese, you can just come to the podium, is fine. All right, and so, Mr. Geese, we are set for trial readiness today, and it looks like this case is set for jury trial on July 29th. I also received a motion from you for continuance, and it's my understanding from reading it that you have some Freedom of Information Act requests that are outstanding. Is that correct?
May I speak freely, Your Honor?
Sure. If you could respond to that, that'd be great.
It's important that I put on the record and identify myself with who I am and who I am not. May I do so, please?
Mr. Geese, I'm not going to play these games. So if you want to respond to that, I'd be happy to have you do that. Okay.
So you're denying my right to speak freely?
Mr. Geese, do you want to respond to my question about the motion to continue?
Yes, I do. I would like to address that.
If you would please respond, that would be great.
For the record, I'm not being allowed to read into identifying myself, who I am and who I am not. The reason for the continuance is I have both FOIAs and transcripts requests that, as you know, take quite a bit of time. The transcripts that I requested is everything up to this point. So it's important that I be able to review everything on the record. Also, continuance with regard to respectfully given prosecution time to answer my motion for discovery, which, if I may ask, wouldn't that, and my affidavit of truth, wouldn't that be considered exculpatory evidence?
We've already addressed that, and we're not going to get into that, okay? They do not have to respond to your affidavit of truth. You get to file whatever you want. They get to file whatever they want, but it's not legally required. So what is it that you are trying to seek with the Freedom of Information Act requests?
Both oaths of office and bondings.
I'm sorry, and what?
Bonds.
What?
Who is bonded and who is not.
Okay, I'm not sure how that has any relevance in your case.
Well, it would have a bearing on not just this case, but what I do with regard to a potential appeal.
Yeah, I'm going to find it's not relevant to this case. Okay. So the transcripts that you're requesting are just for the court's rulings from the prior hearings, because we haven't had any testimony by officers or anything like that.
It's the entire, pardon me, this entire conversation, not just rulings.
Okay. All right. So I'm going to find that that's not required for trial because it is not a transcript of a witness testimony that's needed for impeachment or something like that. That I would certainly consider a continuance for. But there's not anything in the case that would meet those requirements. So
Respectfully, I object.
I understand.
And I don't understand how the court can move forward based on what has been presented and shown without my motion being answered.
The judge wasted no time shutting the request down. He made it clear that the motion had no legal basis, noting that the defendant already possessed the discovery materials and that the transcripts would not contain any prior testimony that wasn't already available. With no valid reason to delay the proceedings, the request for a continuance was firmly denied. The judge then delivered a blunt reminder: choosing to represent yourself comes with real consequences, and with trial fast approaching, there would be no more excuses, delays, or second chances to get prepared.
I have already addressed your motion. So are the people ready to proceed to trial?
Yes, Your Honor.
Okay. And then is the defense ready to proceed to trial?
No, ma'am.
Okay. So I'm not going to grant a continuance based on the things that you've already indicated. Is there some other reason why you need a continuance of the jury trial?
I've stated the reason. Jurisdiction has been questioned. That has not been shown that the court has jurisdiction, subject matter, or personal. And there are several points in my motion for discovery that have yet to be answered. So no to your question.
Okay, I have already addressed all of those issues. The court does have jurisdiction in the case. So I'm not going to find that any of those are grounds for a continuance.
Where is it shown on the record in writing that you have jurisdiction?
So I'm not going to fight with you about this, Mr. Geese. I do have jurisdiction. It happened in Weld County. Okay. So right now I show that we're set for jury trial on July 8 o'clock. So the case will be continued to that date and time for jury trial.
I object.
Okay. Thank you very much. Have a good day.
I would just also like to mention on
Oops, let me have you come back to the podium, Mr. Geese. I'm sorry.
just because I was not able to relay the discovery to you.
Mr. Geese, why don't you face me? Okay. All right. So has he not picked up the discovery?
Not to my knowledge.
Yes, I have.
You have.
You have picked
Okay.
up all
I
the
didn't. I would also like to point out the fact that I believe, if I'm understanding the dates correctly, that we're way past 21 days with providing that discovery.
The discovery was made available to you at the district attorney's office. I've told you that repeatedly when you've appeared in court. Okay. You have to go over there to pick it up. So is there additional discovery, Ms.
I just wanted to note that the body camera video, which I would be hopefully bringing to trial, would be from minute 1:58 to minute 4:01 and minute 36:39 to minute 40.
Okay, those are the timestamps that you're planning to use?
Yes, that's true. And I wasn't sure how to relay that to Mr. Case before now.
All right. Mr.
Let me
Geese,
understand that, please.
sure. So you received the body cam footage on probably on a CD from their office?
Is it, I have the CDs.
Okay, so one of those is probably a body cam, and she's
What kind
indicating.
of file, if I may ask, is that?
Pardon?
What kind of file is
It's
that?
a
Because
video
all I see is a
Should be an
PDF.
MP3 or MP4, excuse me.
Say again?
It should be an MP4. Is that correct in the discovery packets?
Yeah, it's a video file.
So it's an MP4.
I tell you what, why don't I pass the case for just a minute so you can show him the body clips or the body cam clips that you want to use, so that way there's no confusion. How about that?
Thank you.
Okay.
Right.
All right, you can just go ahead and have a seat. They'll do that with you in just a minute.
At this point, the proceedings paused briefly so everyone could review the body camera footage. What should have been a straightforward process had already caused unnecessary delays, but the court took the time to ensure the evidence was properly examined. After a short break, the parties returned to address the footage, and the exchange that followed, while brief, is worth watching before we move on to the next part of the case.
Your Honor, we are ready to recall this case.
Okay.
Geese,
All
please.
right, so court will recall People versus Robert Geese, 26T884. All right, so were you able to show him the body-worn clips that you're planning to use, Ms. Morissette?
Yes, I was. Thank you.
Okay. Mr. Geese, do you have any legal objection to those clips?
I don't understand how the court is moving forward regardless of the discovery that's been submitted by prosecution.
Okay, so it sounds like you don't have any objection to those body-worn camera clips, so the court will allow those to be used at trial. Okay, are there any other issues we need to address from the people?
No, Your Honor.
Any other issues from the defense?
No more than my previous objections.
And I've already ruled on those. Okay, all right. So the case will be continued then to the jury trial date of July 20th at 8 o'clock. We do have several other cases set for trial that day. We'll see where things work out as to whether we can proceed on the case that day or not.
Will this, Your Honor, will this be a jury, a trial by
Yes.
jury of my peers?
We already had this discussion, okay? It's set for a jury trial that day. All right, thank you all very much.
I object. Am I free to go?
Yep, you're free to go. Thank you.
With a jury trial now on the horizon, this case is far from over. Based on what little could be heard from the body camera footage, the upcoming trial has the potential to be incredibly eventful, and it will be interesting to see how everything unfolds in front of a jury. But for now, we're leaving that case behind and heading over to Michigan, where Judge Perkins returns to the spotlight. Waiting for us is Destiny Graves, a familiar figure whose courtroom battles we've been following for years. This next segment is fairly short, so I'll let it play through before we break it down.
City of Detroit versus Destiny Raven Graves, case number SP 1902232, counts 1 and counts 2. SP 1902234, counts 1 and counts 2. Appearance for the record, please.
Elwood S. Berry Jr., on behalf of the defendant. State your full name, Ms. Graves.
Good morning.
State your name for the
You hear
record,
me?
Ms. Graves. Good morning to you.
Can you hear me?
Yeah, state your name for the record, please. Good morning to you.
Destiny Graves. Good morning.
All right, Officer Del Zacchio, good morning to you. Can you state your name, badge, number, department for the record, please? He was here. I don't know where he is now. Mr. Berry, I believe this is going to be set for a jury trial tomorrow.
Yeah, this is a final pretrial, so I would think there'd be an attorney and all.
Yeah, I don't know if she didn't request an attorney. Ms. Graves, are you prepared to handle this tomorrow on your own? I don't think you would be, but I'm going to ask you.
Am I prepared to handle it tomorrow?
Yes.
Yes. Are we going to discuss anything today or no?
I don't have anything to discuss. You haven't filed any witness list. You haven't filed any motions. I don't know if I'm almost positive you don't know procedure.
No, I know procedure. I know that there are certain things that I have to wait on before I make certain actions. But I would like to discuss the matters of my abatement.
All right, why don't you just talk to Mr. Berry and see if he can understand what's going on and he can try to work something out. Mr. Berry, she'd like to discuss some things. Today is the date and time set for a final pretrial. I did have Officer Zazacchio appear, join the room, and tomorrow is set for a jury trial. Join the room, please. We'll pass the matter. Mr. Berry, let's go back on the record with Ms. Graves. Where are we at, Mr. Berry?
We're going on to trial, Your Honor. We could not communicate. She's talking about abatement.
I know, I can't communicate with her either. Coming on into the trial tomorrow in person, ma'am.
In person?
Yes, in person.
Okay, so we're not going to discuss anything today.
Well, we've already discussed everything we're going to discuss. You're going to get your right to a trial, a jury trial, all right, in person. Come on tomorrow at 9 a.m. Let me let Ms. Horn know that as well, to bring her officer in person as well tomorrow morning, jury trial. All right, Ms. Graves, I'll see you in the morning. Have a
I'm
very
sorry,
good
I
rest.
do. One second, I have a question. Give me 1 second. I want to write this down.
I'm not answering any more of your questions. Tomorrow, the jury trial at 9 a.m., okay?
I see. Okay, thank you.
Best of luck to you.
Thank you.
That brings us to the end of that hearing. While her jury trial took place yesterday, it unfortunately wasn't live streamed, so we didn't get to watch the outcome unfold in real time. However, after checking the court records, it appears she was found responsible on one of the 4 charges, while the remaining 3 were dismissed. It's possible that a plea agreement played a role in that result rather than the case proceeding through a full jury trial. Now it's time for our final sovereign citizen case of the day, Francis Hodge, a familiar face we've previously followed through legal troubles in both Kansas and Colorado. As it turns out, his legal issues didn't stop there, because he was recently arrested on similar charges in Missouri, making it yet another state where his arguments failed to overcome the requirement of having a valid driver's license to operate a vehicle.
All right, Kit Carson County Court is in session. Court's going to call case 2025 T-291, the People versus Francis Hodge.
Good morning.
Good morning.
Good morning. Good morning. Can you hear me?
Yes, I can hear you.
Okay.
Can you hear me?
Yeah, I'm at work, so I'm just trying to get you situated on my earpods here. One of them is about to die.
Okay. And let's see here. All right, so it looks like there has been no motions filed. Today is set for a motions hearing.
Mm-hmm.
All right, looks like we're set for a jury trial on August 5th
Yes, sir.
at 8:30.
Mm-hmm.
Mr. Hodges, you're going to
Yes.
be prepared for that. We'll have a pretrial conference at 8:30, and then we'll begin the jury trial at 9.
Right. That's what's listed there. I'd like to had the opportunity to have that extended because I just got out of jail from Wyandotte County, Kansas City, Missouri, where I live, and I wasn't expecting to be incarcerated, but I guess Kansas seems to be quick to incarcerate people for non-criminal acts, but because of the statutes, they considered it criminal, even though there was no injured party. And that put a big
Could
damper.
you move a little bit closer to the mic? We're not picking you up.
Okay, actually here. Hey, boss, hey, let me step aside and get on my speakerphone. They're having trouble hearing me. Okay.
I can hear you now.
Oh, you can? Okay.
Yes.
All right. Yeah. So anyway, after being incarcerated so abruptly, and it was really due to because I was representing myself going pro se. It was a very, very bad experience, and it put a big damper. I did lose my vehicle. Of course, I'm far behind on everything, mortgage, everything, and I do find it very unfair. So I would like either an extension, if possible, to postpone the trial, so I can get some catching up, so my family and I aren't so unprepared, possibly. And either that or is this, what can we do to take care of it today, being that we're here today as well? I would like to also visit those options if that's possible.
Yeah, so I have one more case to take care of, which is a pretrial conference. But after that, I could allow you to speak with the district attorney, Madison Linton, and she can see if the two of you can make resolution. Before I do that, Ms. Linton, what's your position on a continuance?
Your Honor, I'd have no objection to a continuance as long as Mr. Hodge is aware of his speedy trial rights and he waives those rights.
Okay, and so I'll go through that speedy trial rights advisement. But
Okay.
Mr. Hodge, just hang on the line. I'll take care of this other case. And then I'll allow you to speak with her about a pretrial conference. If you can't reach an agreement, then I will give you a continuance. But I will first advise you of your rights to a speedy trial and make sure that you're waiving those rights in order to have that continuance. Any questions?
Okay. No, not at this time. Thank you.
Okay, thank you. Hang tight.
At that point, the court took a brief recess to discuss a possible plea agreement. After considering his options, he ultimately chose to accept the offer, bringing the case to a close without the need for a full trial. It was a significant turning point in the proceedings, marking the end of a legal battle that had been heading toward a much more uncertain outcome.
Your Honor, is it possible to bring Mr. Hodge back from the breakout session?
We're trying. Maybe lost in the Ethernet.
There we go.
There's a +1. Mr. Hodge, can you hear me?
Yes, sir. I can hear you, Your Honor.
Okay. All right. Kit Carson County Court is back on the record on 25T-291, the People versus Francis Hodge. Ms. Linton, where do we stand in this case?
Thank you, Your Honor. In my discussions with Mr. Hodge, I indicated that I would be willing to dismiss counts 1, no proof of insurance, as well as count 3, fictitious plate, in order for him to plead guilty to original count 2, driving under restraint. That is a Class A traffic infraction. It carries a possible penalty of a $100 fine. There could be other court costs and fees. If the court is willing to take that plea orally, and my motion to dismiss 1 and 3 orally as well.
Yes, thank you. All right, Mr. Hodge, you've heard the statements of the district attorney whereby they're agreeing to dismiss counts 1 and 3, which is no insurance and registration of fictitious plates. In exchange for that, you would plead guilty to driving under restraint. It would be a $100 fine plus court and statutory cost. Is that your understanding of the agreement, sir?
Yes, Your Honor.
All right. As to the charge of driving under restraint, how do you plead, guilty or not guilty?
Well, the agreement is for me to plead guilty, and that's what I agreed to, so I'm pleading guilty.
Okay. Has anybody forced you into this guilty plea?
No,
Has anybody
not at all.
promised you anything other than what we've stated here this morning for you to plead guilty?
I would, no, not at all.
Okay. And do you understand the rights that you're waiving by entering this guilty plea?
I do.
All right, court's going to find that you knowingly, voluntarily, and intelligently entered into a guilty plea to driving under restraint. Anything further you'd like to say to the court, Mr. Hodge? You don't have to say anything, but if you'd like to, this is your opportunity.
No, Your Honor.
Okay. So it'll be a $100 fine plus court and statutory cost. Do you have the number to reach back out to the court clerks to make
I do
arrangements?
not.
Okay, do you have a pen handy?
I do not. Would the court be? Oh, hold on. Hey, Toby, can I borrow a pen or your marker? Can I borrow your marker or a pen? Or do you have one on you? I appreciate you. Okay, Your Honor, I am ready.
All right, it's 719 346
346
5524,
5524.
and then pick option 3.
Okay. Is that for the clerk's office?
Yes, sir.
Okay, I actually do have that number here. It's in my old email that I'm looking
Okay.
at.
All right. If you'll call that number, this will conclude this case. Thank you all. Have a good day.
All right, thank you
Oh,
as
yes,
well.
we're
Take
vacating the
care.
jury trial.
Yes.
All right. Thank you. Have a good
All
day.
right.
Thanks, Miss Linden.
You too. Take care, guys.
Thank you, Your
Bye-bye.
Honor.
Thank you.
And with that, we've reached the end of today's video. Out of the 3 sovereign citizen cases we covered, 2 ended in clear defeats, while another appeared to end with the defendant abandoning the fight altogether. As these cases continue to show, the same arguments rarely lead to different results. One defendant spent a great deal of time complaining about the consequences he was facing, but many of those problems stemmed from decisions he chose to make along the way. Time and time again, courts across the country have consistently rejected sovereign citizen theories, reaffirming that laws, licenses, and court authority still apply regardless of personal beliefs. The lesson here is simple: ignoring reality rarely changes the outcome. If you enjoyed today's courtroom breakdown, make sure to leave a like, subscribe to the channel, and turn on notifications so you don't miss the next wild courtroom encounter. Thanks for watching, and I'll see you in the next video.